Hey, Attorney Brian Parker here with another exciting video. This is actually a video, sort of a motion to get a more definite statement 2.0. This is against velocity investment. So what I'm going to do today is I talked about what I want to do as far as a motion for more definite statement and why that is good for you. And it's a new approach I'm taking. So the first one I did, I'm gonna show you so you can take the practical application of what I taught you and see exactly what I do. And I'm gonna give you a couple of documents and I'm gonna do it in a way that will make sense. Okay, so remember when you're doing this, you have really three goals. Number one is to put pressure on the other side for bringing a schlocky lawsuit. So an example of that, remind me about the other two, in case I forget them, is Cindy, put on the screen the complaint, Shazam. So you can see I've highlighted in orange the two things that are gonna get you places. And the first one, let's just highlight number one. Defendant requested a loan from FinWise Bank. Plaintiff, as the current owner, was assigned all the rights, title, and interest to defendant's FinWise Bank loan. There's no evidence of that. And then number two, defendant became indebted to plaintiff upon receipt of the funds. Totally impossible because they just said in number one, let's put number two up there, Cindy, with number one, Shazam. See that? They're saying defendant became indebted to the defendant upon receipt of the funds. It's this FinWise Bank loan, just like Cross River, Upstart, all that stuff, where you apply for the loan, you get it the next day in your account, one of those deals. Velocity wasn't around when this happened. So they've already got a whole plate of wrong. They're saying, we gave you the money and now you're on the hook for us, which is impossible. So I want you to look at the bill of sale, Shazam, and you'll see right there a bill of sale, and I've written, because this is what I do when I talk to the courts, and I want the court to ask this question: who gave this company? And you can see the bill of sale. It's from an Upstart Pass-Through Trust Series 2021 S2. I smile when I say this because they come up with these names. ST8. I will go on a Delaware corporation website and find that company in case the velocity will sneakily go, oh, that's Upstate, just take, because it says Upstate right in the top left-hand corner. It isn't. The Upstart Network Inc. is actually not even in Delaware. It's in Utah, I believe. And Upstart Pass-Through Trust Series 2021 ST8 is a separate corporate entity. It's a trust. And don't let them tell you differently. So we ask, who gave the debt to this company to give it to Velocity on March 24th, 2023? Remember I said that. And don't forget, you're supposed to remind me about those other two reasons. So, and then our third document, Cindy, put it up. And that's what they call a certificate of loan sale, although they never title it. You take a look, if you get one of these things, they never title it. And that's FinWise Bank, the originator here, giving the debt to Upstart Network Inc. Use that alone as your differentiator if they try saying they're both the same. And that was done on 3/31/2023. So let me give you the fourth document I want up there. Cindy, governing law document, Shazam. And that's, you can see 16, highlight that, Cindy. And 16 shows you that you have to file this lawsuit in Utah, either under Utah or federal law. I don't know why you do federal law with a collection debt. So the one thing I told you is you want to get this out front and get them on their heels. Number two, you want this case dismissed right from the get-go. It's probably got a 5 in 100 chance of winning. But that's not really why we're doing this. We want the court, number two, to have an attention, number two-ish, to the schlock that they bring. Let the schlock shock the court. and you bring attention to this without even answering. So number 3, this is a motion that occurs before the responsive pleading. The responsive pleading is your answer, your affirmative defenses, and while it's not a responsive pleading, you can do it at the same time. You can do a counterclaim. So that's all based, the reason I showed you those documents is that's what you want the court to see, to have it in front of it. Here's what I want. You're right, you should dismiss this case. And what I say is, or in the alternative, so it's a win-win. If they dismiss it, it's a big win. But courts are, they're kind of King Solomonish. They want both sides to win because it's tough to make them until the end of the case when they want you out of their hair to make them go to one side. So you get a win by going, hey, if you can't give the dismissal, give me what I'm really looking for is the right documents. And when you win a motion for more definite statement, generally in your state, check out the rules, they've got an amount of time to give you all they're supposed to have given you in the first pleadings. If they don't, it's automatic default. So it's a win-win in that you give this thing, you go, hey, judge, I want 100%. And she goes, I'm not doing that. I'll give you 50%. I'll give you a motion for alternate to forget more definite statement, putting the burden on them, which it's supposed to be. So the next thing we do, those documents I just showed you, we go and we create our counter affidavit. See all my videos on counter affidavits. There's even a free video, a PDF free. Here we go. Cindy put a bunch up there. There they are. Swish. So you want, by the way, all those videos and hundreds of other videos are on my membership website, collectionstoppersolutions.com. Get some. It's really good and it's a great price. So we create our counter affidavit. Why? Because we want to support any effort we make in front of the court. We're not like these guys. And there are certain documents that we use in our case against them. What documents do we use? What documents? Come on. That's right. We use their own documents against them. And so I just showed you a couple of documents, including the lawsuit. So my counter affidavit will show you, will point to those documents. So Cindy, go to page 1 of the counter affidavit, Shazam, and you can see at the bottom there, I used their loan agreement, what they call the approval disclosure form. It's like a TILA deal, and that shows who the creditor is, FinWise Bank. Why am I doing that? Because I'm saying, fourth, according to the loan agreement attached to the lawsuit, the debt was originated by FinWise, and it would be an initial seller as the original owner, creditor of the loan. That's their own document says. But if you looked at the bill of sale, put up the bill of sale, Cindy, Shazam, and you can see right there, this weird entity, this trust is saying it's the initial seller. Not possible. So you use their own documents against them. I may have mentioned that a couple 100,000 times before. Cindy, go to page 2 of the counter affidavit, Shazam. You can see number 7. The lawsuit at paragraph number 2 states defendant became indebted to the plaintiff upon receipt of the funds. Remember I showed you their complaint? Number 8. Put up 7 and 8, Cindy. Shazam. This would be impossible as the plaintiff was not around when the loan was supposedly provided to me by the original creditor, FinWise, in 2021. So put up paragraph 1 alone. You'll see number 9, and put up paragraph 9. Put up paragraph 9 through 10. Sorry for the confusion. Paragraph 1 itself says defendant requested a loan from FinWise Bank and not plaintiff defendant. Not plaintiff. Defendant would not be indebted to plaintiff in 2024 or 2021. And then I show the paragraph of the complaint and I say, I don't know what to do with this information or answer this properly with conflicting, confusing allegations of ownership of the debt or loan. I say that because in your desire, in a motion for a more definite statement, you have to allege that this thing's either vague or confusing or just unable to respond to. So that's a terms of art that you have to put into any motion for a more definite statement. And then, Cindy, go to page 3 for the fine folks here. And you can see there's that what's called a certificate of loan. And that's signed on 3/31. And you make no bones about that. In fact, I say, survey says, if put up paragraph 11 of the counter affidavit, Shazam. Further, another loan sale document attached to the lawsuit states that on March 31st, 2024, FinWise transferred sold loans to Upstart Network 6 days after something was sold to Velocity on March 24, 2024. So Cindy, make sure you got the edge of that on the next page. So you make the point, how can they have sold something to Velocity in the bill of sale and from an entity who we don't know how they got the loan, and then 6 days later the original creditor sends the same debt to Upstart Network? You also have to make the point, and this is what I do, and just focus on paragraph 12, Cindy, Shazam. There is no proof or showing what was transferred between FinWise and Upstart Network, and I am struggling to see how Velocity has a right to sue me if the debt was sold to Upstart Network Inc., and there's no evidence of Upstart Network Inc. selling the debt to Velocity. So how could plaintiffs say defendant had to be indebted to the plaintiff? Because it's just a broken, messed up chain of title. And then you point out the loan agreement, which I just showed you that fourth piece of paper, the governing law. Cindy, put up the last page of the counter affidavit, Shazam, and you can see from quoting from their own loan agreement, the governing law says, why is this stuff in Michigan? I write number 14. I have no idea how to answer this lawsuit with federal or Utah law and believe the plaintiff has breached the contract in this lawsuit, and I don't want to breach it and unsure how to answer this. So you're showing good faith, clean hands. And what those 4 documents I showed you, they get attached to your counter affidavit, right? So where am I going with this? You're building up because the counter affidavit, you're going to need it when eventually you answer if you don't win your motion to dismiss. You then file, I'll just put up the first page, your motion for summary dismissal, or in the alternative, more definite statement. Shazam, first page. You can see that, Cindy, and you can see that fine fellow warriors out there. Plaintiff Velocity Investments has sued defendant Mr. Debtor on a debt plaintiff claims to own but has no proof of being assigned the debt. And then you, guess what you do? Show second page, Cindy, Shazam. There's the complaint you just saw me using that I used to create the counter affidavit. You'll also, on the same page 2 of the motion, I'm quoting paragraph 2, that devilishly wrong, impossible paragraph 2. I quote paragraph 1, and then go to page 3, Cindy, Shazam, a little nod, Shazam. And there, on the top, further, another loan sale document attached to the lawsuit states that on March 31st, FinWise transferred or sold loans to Upstart Network 6 days after something was sold to Velocity. So this is a trial technique. You keep repeating the main message, stay on message, and you may just get a dismissal because here's how you get a dismissal in most courts. If you can show there's no claim here, there's no, they have no standing, they have no basis for showing how FinWise got the debt all the way to Velocity through these twists and turns that are completely broken. You keep saying that, and the court's going to get it. You say it verbally in your motion hearing, you say it in your counter affidavit, you say it, you show their documents, and you're going to do just great. And I bold what I really want the court to know, and I'll put my little pink sticky note there. And it says, this debt transfer occurred 6 days after the bill of sale and would make it impossible for Velocity to have received anything prior to FinWise Bank passing it on to someone else. The only frustrating part of this, usually for me, is as I'm writing and reading this, I'm going, why is this going to go anywhere but to a motion to dismiss? But you've got to think like the court is not going to be that draconian at the very early stage. Remember, we bring this motion or a motion to dismiss that's based on their not having a claim before the answer. And most state rules say you've got to answer the lawsuit in 20 days or 21 or 30. However, if you file a motion to blah, 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 motion for a more definite statement, motion to dismiss, you're allowed to do that and not have to answer or fear any default, because you're essentially saying to court, why am I bothering with an answer or any of this? They haven't even brought a good claim. In fact, they don't have standing. So I think what was important to me that I show you what I am looking for to delineate my whole methodology here. So Cindy, put up the last page of this motion, Shazam. So there's always a wherefore clause. A wherefore clause says, this is what I want, court. So when you get sued, they'll go, wherefore plaintiff is blah, 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 I want $6,000. So I'm here going, hey man, you got no right to sue me. Wherefore, defendant, we got it up? Do we have it up? The fourth page. Defendant through counsel, the law offices of Brian P. Parker, whatever, you put your name in there. Number one, I want you to dismiss this lawsuit as it lacks standing to sue defendant, or in the alternative, so remember at the beginning I said you're probably got a wish list here. You're not going to get that 5 out of 10, 5 out of 100 possibility, but you really want those other two things, right? Then I write, grant an order for the plaintiff to provide the proper paperwork showing a chain of title of assignments from the original credit, FinWise Bank, all the way to Velocity, and how Upstart Pass-Through Trust Series 2021-STA obtained the debt 6 days prior to FinWise actually transferring it. So you're already sticking it to them, and here's the best way you stick it to them. Then I say number 3, show an assignment of the debt specific to defendant, meaning I want to see David Debtor's name and the account number from Upstart Inc. to Velocity within 14 days of the quarter. There's a couple of reasons why I'm asking for that, but the number one reason is the little devil in me. Problem Parker's his name. There is no such animal. But now, when the court says, I'm not going to give you a motion to dismiss, she sees the alternative, she's going to order this. And you can use it against her down the road if she tries to dismiss your case, but you want to use it against these folks who will, by this point, just want to settle the case and get you out of their hair, all right? And of course, the all-inclusive number 4, of a relief to the defendant set by the court. So that's a beautiful thing. Shoot for the moon, shoot for the stars, and settle for the moon. It's not a settlement, it's a stick in the eye of the other side for bringing a schlocky, shocky, bad complaint they thought they can get away with. And we have this methodology here. What do we do? What do we do? You got it again. We use their documents against them. And I did what they call a paper trail here. Here's what they gave us. Goes into the counterclaim, goes into our motion. And that is your Velocity motion for dismissal, but in the alternative, motion for more definite statement 2.0. Practical application of the first video I showed you. Show the first video. Cindy, boom. And I would like to thank you for viewing this. I hope this helps. It should. I always try to break it down. This should break it down. Just fit your court rules and state law in and your facts and go to work. I am actually doing this, no lie to you. I'm pointing back here to my screen. A gentleman asked, hey, when are you going to do something like this? So I said, I'll do it in 5 minutes. And here it is. So I listen to you if you ask me to do a particular video. So like, love, and subscribe. Let us know we're doing okay. Subscribe. Our membership website, hundreds of videos, all the templates. On this video, there's going to be the counter affidavit. There will be the actual motion, and I will put up their documents just so you can see what I'm doing. And I will put up the show notes from the other video because I didn't do show notes from this. I literally got my marching orders from my member on my chat and my live stream. and just did this for you. So I hope it's good for you. Like, love, and subscribe. Brian Parker out. Thank you.